Good afternoon. Oh, it's not afternoon. Good morning, everyone. Are you able to hear me and see me well?
Good morning,
Yes,
Judge.
Yolanda.
Yes, we
Good
can hear you.
morning, everybody.
Good morning. Courtroom 2 is here, so and ACDC is here, so we can go ahead and get started. Good morning again. This is the State All Purpose Calendar in the State Court of Fulton County, Georgia. I am Judge Melanie Williams. Today is July the 9th of 2026, and at this State All Purpose Calendar, we will address matters including arraigning cases, take pleas, and set bonds for cases previously reset from our state expedited accusations calendar. All defendants, you have certain rights today, including the absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney today, and many are present at the jail with you or here on Zoom. When I ask if you understand your rights, that is what I am referring to. Have all defense attorneys had the opportunity to interview their clients, or are there what's the word I'm looking for? Outstanding interviews that need to be conducted?
Your Honor, if I can make a quick announcement on position number 37 and 38, Janisa Ross.
Mhm.
I've spoken to her, but I still don't have a recommendation from the state. So my point is, if they're gonna make an offer, I need to speak to her again. I just want to let the court know.
Okay. All right. Are there other parties that need to interview someone at the Fulton County Jail?
Not from me, Judge. I'm just only handling the ACDC cases.
Okay.
I think we do still have a couple going on, and then once they bring in the client from Cobb, I'll need to speak with him. I haven't had a chance yet. I've
Okay.
been with most of my clients, but there's one or two I still need to.
All right. And if there are new offers, please do convey those to Mr. Haddad and Mr. Judd and Mr. White. All right. Are we ready for hi, Mr. Bartels. Good to see you.
Morning, Jess. Good to see you.
Morning.
I just have one client to talk to that's on the SAP calendar, and he's here.
Okay. Okay. Thank you. All right. Can we begin?
Let courtroom 2 go first because I'm waiting for Attorney McLeod to log on.
Okay. That works. Is there anyone we can take at courtroom 2?
We're going to number 28, Mr. Lemus.
Okay, give me 1 second. One second. Okay, I couldn't print the calendar this morning, so that really stood in my way.
Mr. Edwards. Yeah, Mr. Edwards.
Give me 1 second. Thank you for your patience. Hold on.
Of course.
Okay.
Hello. Yes, sir.
Okay, and of course the calendar won't open now. Okay, this is position 28. All right, Mr. Lemus, your case is 26 CR 004256A. You're charged with loitering and prowling and theft by taking. Do you fully understand your rights today?
Yes, ma'am.
All right, thank you so much. Um, and Miss Morgan, or is this Miss Love? Whose case is this for the state?
It's my case, Judge.
Please proceed.
The state's offer for count 1, loitering and prowling, is 12 months probation. For count 2, theft by taking, 12 months probation, serve 5 days in jail, balance probated, an anti-theft course, restitutions to the victims, and no further contact.
And the victims' names for the record?
Uh,
I have it's is it this Cortez Lorenzo, Jesus Roper? Are these am I saying the correct parties? Matthew Mitchell and Mohammed Karashi. Are any of those parties present at this time and wish to make a statement? Okay, hearing none. Mr. Judd?
Your Honor, there was no mention of restitution in the offer, so if that's now included in the offer, I'll need to speak with Mr. Lemus about that.
Okay, is there a restitution? I don't see that on the calendar either as the recommendation, Ms. Love. So are you now asking for restitution?
Judge, yes, it's in my notes. I don't know how it would have been omitted, but I'd be happy to communicate with opposing counsel about that.
Okay. Why don't you take a look and tell us if that's still, are you asking for the restitution to stay open a certain number of days afterwards, or
Yes, Judge,
does,
yes, if we could keep restitution open for 30 days.
okay, so Mr. Jett, would you like to speak to your client about that? Apparently restitution is a portion of the offer today.
If I may have just 30 seconds.
That will work.
Sir. Your Honor, that is acceptable to Mr. Manis.
All right, sir, please raise your right hand today if you wish to take a plea. Do you swear or affirm the testimony you give today for the very limited purpose of taking the plea will be the truth to the best of your knowledge and is given under the penalty of perjury? Is that a yes? All right, speak as loudly as you can for me, okay? Thank you. Are you under the influence of any drugs or alcohol at this time that would affect your ability to take a plea?
No,
Did anyone force you to take a plea today?
no,
Did anyone promise you anything in exchange for taking a plea?
no,
You understand you're giving up your right to trial by a judge or jury,
yes,
and you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
yeah, yeah,
And you understand there'll be no other court dates about these charges?
yes, ma'am.
And do you fully understand the requirements as explained to you by your attorney?
Yes,
And you're satisfied with Mr. Judd's representation today?
I am.
Thank you. You make this plea knowingly and voluntarily?
Yes, ma'am.
As to the charges of loitering and prowling and theft by taking, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from state or from the defense?
No,
Yes.
Judge.
All right. Best of luck to you, Mr. Limits. This case is now closed.
Your Honor, I'm sorry, there was something.
Oh, I'm sorry. Go ahead.
Your Honor, we would ask that once he has paid restitution and taken the anti-theft course, that his probation terminate. And also, I don't believe we had stipulated 3 factors, but we do so.
Oh, my apologies. Correct. Thank you, Mr. Judd, for catching me. You do so stipulate that was your understanding of the offer. And he can go, I will do this. I will waive 1 month of fees and he can go non-reporting once he's completed. Okay?
Thank you, Your Honor.
All right. Best of luck to you, sir. Thank you. And thank you, Mr. Judd, for that.
Yes, ma'am.
I'm struggling a bit this morning, so thank you.
I think
All
we
right.
all,
It's been a morning already. All right, who do we have next?
no, okay. You'll get paperwork as your process. We do Jamari Love.
All right, 29, Mr. Love.
Okay. All right, Mr. Love, good afternoon. This morning. Good morning, Ms. Love. Your case is 26 CR 004309B. In this matter, you're charged with theft by shoplifting. Do you understand your rights today? All right, thank you. Is this your case, Ms. Love?
Yes, it is, Judge.
All right, please proceed.
The state's offer is 12 months probation, served 3 days, balance probated, a $300 fine, and anti-theft course,
All right.
and a stay away. Excuse me.
Where's the stay away from?
Let me pull it, Judge. I don't have that right here.
We do need that address. I'm assuming it was a retail store, but that might be an improper assumption.
Okay, just a moment.
All right. In the meantime, Mr. Judd, do you so stipulate to the 3 elements, and was that your understanding of the agreement?
That was our understanding, and we do so stipulate. For the record, he has been in custody for 13 days at this point, so he should be done with jail.
Okay, thank you. Mr. Love, while Ms. Love is looking for that address, please raise your right hand. Do you swear? Wait, first is raise your hand if you wish to take a plea. Do you wish to take a plea today?
No.
All right, thank you. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury? All right, thank you. Speak as loudly as you can. You can put your hand down. Are you under the influence of any drugs or alcohol that would affect your ability to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No.
Did anyone force you to take a plea?
No.
You understand you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you understand you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
No.
Do you fully understand the requirements, including the time you served in jail, the $300 fine you'll need to pay, the course that you'll need to take, and the stay away? We're going to tell you where that location is shortly, but do you fully understand those requirements as explained to you by your attorney?
No.
And you understand that taking a guilty plea can affect other aspects of your life, such as employment, probation, immigration, any other open cases. Do you understand all of that?
Yes, ma'am.
All right. As to the charge of theft by shoplifting, how do you plead?
Yes.
I accept your guilty plea at this time. Is there anything additional?
Yes, Your Honor. Would Mr. Love be allowed to go early termination once he's completed his anti-theft course and paid his fine?
I'll allow him to go non-reporting once it's completed. All right?
Thank you, Your
All
Honor.
right. All right. Best of luck to you, sir. Who do we have next?
Number 30, Mr. Mayor.
And Miss Love, did we ever get that stay away location? We do need that.
Judge, I see this as CVS, but I was trying to pull the actual address, which is
Okay.
not.
If you could chat Mr. Jordan that address for sure, so we make sure it makes its way onto the order. Okay?
I will, Judge.
Thank you. All right, Mr. Mack, good morning. Your case is 26 CR 0042663H. You're charged with wearing a mask or a hood, obstruction, and public drunk. Do you understand your rights?
Yes.
All right, thank you. Miss Love, is this you as well?
Yes, Judge, it is.
All right, please proceed.
The state's recommendation for count 1 is 12 months probation, 7 days jail. For count 2, willful obstruction of law enforcement, 12 months probation, OP 21, a $300 fine, 7 days jail concurrent to count 1. And then for public drunkenness, count 3, 12 months probation.
Okay, that's different from this calendar has as well. So we've eliminated the community service.
Judge, I will defer to your notes and I will try to obtain the document that you have in just a moment.
No, that's fine. I mean, I'm not adding it. I just wanted to make sure because the original offer I saw had more jail time, and it also had community service. But so 7 days in jail, the law and decision making class, a fine, and just being on probation. That's your understanding of the offer.
Yes, Judge, that's my understanding.
Okay. All right. Mr. Judd, do you so stipulate, and was that your understanding as well? Was that what was negotiated?
We do so stipulate, and in fact, Your Honor, that's better than what we negotiated. So we will have.
Okay. It's better than what I see here as well. All right, Mr. Mack, please raise your right hand if you wish to take a plea.
Yes.
Do you swear? No, okay, hold 1 second. Do you swear or affirm the testimony? Wait, put your hand back up, please, Mr. Mack. Thank you. You're doing a good job. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange?
No.
You understand you're giving up your right to trial by judge or jury,
Yes.
and you are fully satisfied with your attorney's representation.
Yes.
And do you understand all the requirements as explained to you by your attorney?
Yes.
All right, as to the charges in the case ending in 4263H, how do you plead, Mr. Mack?
Guilty.
I accept your guilty plea. Is there anything additional from state or defense as it pertains to this case?
Your
No,
Honor,
Judge.
I'm sorry.
I'm sorry. Go ahead, Mr. Judd. I'm assuming you're asking for some early termination or some non-reporting.
Yes, Your Honor. We're asking that Mr. Mack be allowed to go non-reporting once he's completed the conditions. And just for the record, he has 14 days in custody as of today.
All right. So it seems that the time he served should close his case. All right. Best of luck to you, sir. You can go non-reporting once all the requirements of the sentence are completed. All right. This matter is closed. Who do we have next?
Thank you, Your Honor.
Number 44, Mr. Wheelock.
I'm sorry, number 44.
Yes, ma'am.
All right, thank you, Mr. Wheelock. Good morning. Your case is 26 CR 001419C. In this matter, you're charged with obstruction. Do you understand your rights today, Mr. Wheelock?
Yes, ma'am.
All right, I have that this is also a negotiated plea.
Yes, Your Honor.
No, oh, it is?
Okay, I'm sorry, Miss McLeod. It's not negotiated.
The
Your
offer
Honor,
was sent out yesterday.
Okay, hold on. Let's go one at a
I'm
time.
sorry, what did you say?
Is it? I thought the Miss Morgan is under the impression that you have consented to the offer, Miss McLeod. Is that incorrect?
I have not spoken to Mr. Wheelock, and I was a little bit confused because I received an email last week saying that his private counsel had requested that this case be put on the SAP calendar. He does have private counsel in his felony case. I contacted that private counsel and I explained to her what was going on, and she informed me that she did not represent Mr. Wheelock in this case, that as far as she knew, I was still representing him. I actually emailed her about this morning's proceedings and sent her the links. I don't know if she is on.
So
I have not
I think it's safe to assume that you represent him, Miss McLeod. Can you call the jail and give him a call to see if we're going to take the
Yes, Your
plea
Honor,
tonight?
because I certainly haven't spoken to him about the state's plea offer.
That's
So
fine.
I'm not sure who the negotiation was made with. So I just want to be safe that he does not have private counsel or some other lawyer representing him, because I have not spoken to him.
I don't believe he does. I think I remember this matter. Miss Morgan, did you speak to anyone other than Miss McLeod as it pertains to this case?
No, Your Honor.
Okay, Miss McLeod, if you could give the jail a call and we'll go to
I will, Your Honor.
all right, and we'll go to another position in the meantime. Can we go to ACDC? Oh no, Miss McLeod's gonna make the phone calls. So who do we have next?
Hold on one second. Cases. Buyers, you here? Want any buyers? Deborah, we got Deborah. Deborah. We'll go to number 10, Mr. Deborah.
Yeah, here, he's right. You want to have to sit over here.
Okay, Mr. Devereaux, good afternoon. I cannot get that together. Good morning. Your case is 26 CR 004265J. You're charged with disorderly conduct and terroristic threats. You understand your rights today?
Yes, ma'am.
All right, I have that. I have no announcement. Mr. White, is there an is Mr. White there? I haven't seen Mr. White.
I am, Judge. Yes.
Oh, you're on Zoom. I was looking for you at the jail. Okay. Is there an announcement for this case?
I spoke with him this morning, Judge, and it'll be negotiated plea.
Wonderful. Thank you. Miss Morgan, if this is your case, please proceed.
This is actually my case, Your Honor.
Oh, okay. All right. Miss Douglas, please proceed.
Yes. So, count 1, disorderly conduct, 12 months to serve, 30 days, credit for time served, balance probated, 20 hours of community service, and a law and decision-making course. For count 2, terroristic threats and acts, 12 months to serve, 30 days, credit for time served, MHET, a 12-month treatment plan with compliance, including medication management.
Okay. Mr. White, that was your understanding, and you so stipulate to the 3 elements?
Yes, Your Honor, we do stipulate the 3 elements just for clarity's sake on the mental health evaluation. That would be if there's a treatment plan, correct? Because it's an evaluation.
Right. If after they evaluate him, if there's no treatment recommended, he wouldn't have anything to do. So I think that's clear. All right. All right, Mr. Devereaux, if you wish to take a plea, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given under the penalty of perjury? All right, you can. All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding?
No.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange?
No.
And you understand that by taking a guilty plea, you're giving up your right to trial by judge or jury?
Yes.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt? Is that a yes?
Yes.
All right, you're satisfied with Mr. White's representation?
Yes.
And you fully understand the requirements as explained to you by your attorney?
Yes.
As to the charges of disorderly conduct and terroristic threats and acts, how do you plead, Mr. Devereaux?
Guilty.
I accept your guilty plea. Is there anything additional?
No.
All right, best of luck to you, sir. This case is closed. Mr. White, Ms. Douglas, anything additional from you?
Your Honor, I did want to add continuous reporting to probation with random drug screens.
Okay, that was your request. Okay, I see that. Was that your understanding as well, Mr. White?
Yes, Judge.
All right. Best of luck to you, sir. That concludes this matter at this time.
All right.
Next, we have 13, Mr. Duplessis.
All right.
If
This is a bond hearing, Mr. White.
that's correct, Your Honor.
All right. What is his current bond? Is this your case? Whose case is this for the state?
It's my case. I'm pulling it up for you. Give me 1 second.
Okay.
It's 12.
Go
It's
ahead. I'm
12
sorry.
Judge, it's $12,000 bond.
Okay. All right, Mr. Duplessis, your case is 26 CR 004269J. You're charged with fair evasion, obstruction, assault, and disorderly conduct. Do you understand your rights today?
Yes, ma'am.
All right. Let me see. I'm looking for my own notes. Did I set this bond?
Is Judge Mintz.
Judge Mincy set the bond? Okay.
Yeah, I'm sorry, Judge, if you don't mind, I'm trying to, I'm having technical difficulties, so it's hard for me to manage everything on my phone that I'm trying to. But there may be an offer for that. I know there was an update from our victim advocate. If you will, please just give me a moment to verify whether or not that's this case in this particular instance.
Okay, so Mr. White, there may be a different offer for your client to consider, so maybe we come back to this case in a second. So just hold 1 sec. We're gonna hold on number 13 while Miss Evans Battle takes a look, and let's go to another position for right now.
Want me to step back or?
Yes, please. Yes, please, sir. We're gonna come back to you. Okay.
Second. Item 14, Mr. Edwards.
All right. Mr. White, this one is
It's a negotiated plea, Judge.
negotiated plea. Thank you, Mr. Edwards. Thank you. Good morning. Your case is 26 CR 004262K. You're charged with simple assault, family violence. Do you understand your rights today?
Yes, ma'am.
All right. Thank you so much. Is this Miss Douglas's case?
Yes.
All right, Miss Douglas, please proceed.
The state's offer is 12 months to serve 30 days, credit for time served, balance probated, stay away from 3200 Lakeview Place, apartment 207, no further contact with La Paris Abercrombie, FVIP, and 40 hours of community service.
Thank you. Is LaParis Abercrombie present and wishes to make a statement?
Yes, I am.
All right, please turn your camera on. Please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge?
Yes.
All right, what would you like to tell the court today?
Um,
You can put your hand down. You can put your hand down.
what I would like to tell. I don't have anything to say. Would y'all need my statement or something?
No, you're not required to make a statement. It's just that if you wish to speak or tell me something, this was your chance to, but you don't have to if you don't want to.
I don't have anything to say today.
All right, thank you for coming to court. I appreciate you. All right, Mr. White, was that your understanding of the offer today? And do you so stipulate to the 3 elements in this case?
Your Honor, we do stipulate for the purposes of plea. We would just ask that the probation go non-reporting once he completes all of his requirements.
All right, I will allow that. Mr. Edwards, if you wish to take a plea, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding today?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
Do you fully understand the requirements of the sentence, including the fact that you're to have no contact with Miss Abercrombie? You're going to take a 6-month class. You're going to do the 40 hours of community service, and you are to stay away from that location upon release, as well as all the other requirements as explained to you by your attorney?
Yes.
And you understand that taking a guilty plea can affect other aspects of your life, such as employment, probation, immigration, or other matters your attorney or I may not be able to anticipate?
Yes, ma'am.
All right, as to the charge of simple assault, family violence, how do you plead?
Yes.
I accept your guilty plea. Best of luck to you, sir, and if there's nothing additional from the state of defense, we'll move to the next case.
Nothing from the defense, Judge.
Thank you.
Nothing further, Your Honor.
Go back to 44, Mr. Wheelock.
All right, Ms. McLeod, your announcement for Mr. Wheelock?
Yes, Your Honor, this is going to be a non-negotiated plea.
Okay. Since it's non-negotiated, Mr. Wheelock, I think I gave you your case number, but let's just see, 26 CR 001419C. You're charged with obstruction. Miss Stallworth, may I please have Mr. Wheelock position 44's history in light of the non-negotiated plea?
Good morning. Yes, Your Honor. Give me just a moment.
Good morning. Uh-oh, I'm losing power.
Okay, he has 3 cycles total. One moment. There's a 2024 first offender that he's currently on probation for out of Clayton County for theft by receiving stolen property, willful obstruction, and criminal use of an article with altered ID mark other than motor vehicle and fleeing or attempting to elude, and nothing further.
Okay, thank you. The state's offer at this time, Ms. Morgan, is what? And if you'll give me a very brief factual basis for this case while I look it up as well.
Yes, Your Honor. Just one moment. This one has a very long probable cause.
While she's looking that up, Your Honor, my apologies. There are some open felonies in Odyssey.
Okay.
25 SC 007411, unlawful acts of violence in a penal institution. I'm sorry about that. Possession of dangerous weapon or drugs by inmate. And then the other case is 25 SC 005858, armed robbery, aggravated assault, willful obstruction of law enforcement officers, possession of firearm or knife during commission, and possession of firearm by convicted felon.
Okay. Thank you, Ms. Sauer.
And Your Honor, the state has the factual basis. So on February 23rd of 2026 at 901 Rice Street, which is the jail, the defendant, not the defendant, but overall there was a riot within the jail. The defendant was in the midst of the riot. He did not cause any violence or any type of physical interactions to anyone during the riot. But when he was pulled out of the riot and he was asked by Sergeant Smith who he was so that they could identify all of the individuals, get everyone, so that they can identify everyone involved, the defendant lied and said his name was Chris Angel. So it caused some confusion and, just misunderstandings of who he was and where he needed to be and what was going on with him specifically. So that is the result of his charge.
Okay. And the recommendation from the state is?
Yes, Your Honor. At this time, I'm assuming since it's non-negotiated, we're taking up bond. Is that correct?
No, I want to know what your recommendation
No, we're
is.
not.
So the recommendation is 12 months probation, balance probated, 40 hours of community service, and it is Operation 21 Law and Decision Making course, and $300 fine.
Okay. And how many days has he already served in the Fulton County Jail, Ms. McLeod, to your knowledge?
To my knowledge, Your Honor, he's been in since, I think, January, February of this year. It's been some time.
I've been here since.
But the state
No,
has
don't
that
say anything.
information.
Don't say anything, Mr. Willock. Let me look and see. On this, when did this happen? This happened in February. Okay, so that was the state's recommendation. Ms. McLeod, your recommendation today?
My client is willing to plead if it's going to be time served, Your Honor, based on what is alleged and the fact that he's been sitting in jail for some time. I do not see a need for him to be on probation, pay a fine, and also do that course. I do not think it is necessary based on what the state is alleging happened and the amount of time he's already served in jail, Your Honor. So we are looking for a straight time served.
Okay, I don't know that I'm gonna do that. Let me look at one thing. Is this the only charge holding him in?
No, Your Honor.
He has other matters pending. Let's see.
Yes.
Oh, correct. It's correct. Ms. Stallworth said that he has the open. Okay. Let's see. All right.
Furthermore, we don't know when he's going to get out to do all those things they're asking for, and it just complicates things for him when he has bigger fish
I
to
understand,
fry.
but I mean,
You know, all they're saying was that he gave a false stand. That's all
and
the
that's
allegation
I
is
know,
in
but that's still
jail.
not good. That's not great, Ms. McLeod. That's not great
It's
either,
not
though.
great, Your Honor, but
Not
you know,
good.
in terms of obstruction, it is not major.
Well, you know, we all have perspectives on these things, Ms. McLeod. I'm looking at something. Give me a second. Mm. All right. I will allow him to say time served if he wishes to take the plea today. All right. Does
Thank
he
you,
still
Your
wish to
Honor.
take the guilty plea, even though it may have? Okay, I'm gonna ask. Let's see. He still wishes to take the plea. Raise your hand if you wish to take a plea. All right. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yeah.
All right. Do you swear? Okay, you can put your hand down. Are you under the influence of any drugs or alcohol at this time? Speak loudly, sir.
No, ma'am.
All right, thank you. Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
You understand that taking a guilty plea, you're giving up your right to trial by judge or jury.
Yes, ma'am.
And you understand that taking a guilty plea can affect your other open cases, probation, immigration, or other matters I may not be able to anticipate?
No.
All right. Do you take this plea knowingly and voluntarily today?
No.
And you're satisfied with Ms. McLeod's representation?
Yes,
Wait a
ma'am.
minute, hold on, but I've just thought of something, Ms. McLeod. The $300 fine is statutory, so we would not be able to just time serve that portion. I forgot about that for obstruction. So in light of that, if he would have to either do 30 hours of community service or pay the $300 fine, would you, does your client still wish to take the plea in light of that requirement that I cannot waive?
Yeah.
You say yes, sir, you still want to take the plea?
Yeah.
All right. So on release, you understand that you will either have to, you will have to pay a $300 fine. You still wish to move forward and take the plea today?
Yeah. If I pay $300 fine, I don't have to do the community service.
All right. It's either, Ms. McLeod, why don't you explain it to him? I don't want to, can you call the
Yes,
jail
I will
again?
explain it to
And
him.
understand that he will have to be on probation, pay something until the fine is paid. If he pays it immediately, he could go non-reporting, but there would, that's a statutory fine. I cannot waive that.
I will speak to him.
Okay, so we'll come right back again to Mr. Wheelock just to clarify that point, and then that'll be the last question. All right, can we temporarily go to another position and come back to Mr. Wheelock?
You gotta vote, right?
Your Honor, we can do Attorney Haddad, Ms. Ross, position 38 and 39. Do they have the offer already?
I don't think so. I think that was one of the ones. Is there an offer yet for Ms. Ross?
Your Honor, there is not. We have not been able to successfully get in contact with the victim.
How many
So
times has she been on SAP? Is this the first or second time?
That was the first time, Judge. This is the
Okay,
first.
we'll reset it one time, more for an offer, okay? But we this I don't know, like this situation is starting to feel troubling a little bit that we continue to have cases brought with no offers. Mr. Haddad, do you have any other requests, or do you wish to reset it 1 week?
Your Honor, I mean, we can argue for a bond, but she's got an old case that's also keeping her, so I'll just ask to reset it. The state was gonna null pros the old case if there's a plea on the newer case, but under the circumstances, Judge, we'll just
Is
reset it for
she's
next week.
being held in on the license case?
That's one of the charges, yes, Judge.
But is number 38 the only thing holding her in, or there's another older case somewhere?
No, those are it. The ones that are on the calendar, Judge, are what's keeping her. I mean, I would normally ask for a signature bond through pretrial services, but yeah, I mean, I don't know if that was. I don't know right off the top of my head whether that was presented to the court back at SEA or not.
I'm assuming it was, but didn't fly. Hold on 1 second. Miss Stallworth, can I please have the history for number 37 before I reset it?
Yes, Your Honor, one moment.
Some driving charges are holding her, a license suspended.
Your Honor, she also has a $2,000 surety bond in position 37, battery, family violence.
Right, I'm assuming that. I know that, but what I'm saying is that second case is okay. Let's hear the history.
Okay, she has an active warrant from Fulton for FTA. Date of that warrant is August the 3rd of 2018. There are 18 cycles total. There is a FTA in 2017 from DeKalb County, FTA in 2017 from Fulton. There is a 2017 conviction out of DeKalb County for possession of cocaine and giving false name. There is a 2015 NOLO from the city of East Point for driving while license suspended or revoked. And then there is a 2013 first offender out of Henry County for theft by shoplifting and possession of tools for commission. One moment. There's a 2010 out of Dunwoody for theft by shoplifting, and a 2010 out of another 2010 out of Dunwoody for theft by shoplifting. And then nothing further.
Okay, so we'll take up a bond argument for this one, okay? Before we reset her. Miss Morgan, let's start. Ms. Ross, is Ms. Ross there? Can we bring her forward?
Yes.
She is, and what is the bond she has on the driving while license suspended, Miss Morgan?
1 second,
It's 2,000, Judge.
On the driving, I know it's 2,000 on the battery.
It's also 2,000. So it's $1,000 on each of the traffic charges from the 17 CR case for a total of 2,000.
Okay. Ms. Ross, your case is 26 CR 004429B. You're charged with battery family violence, and you also have 17 CR 007815B, which you're charged with driving while license suspended and failure to have your license on person. Do you understand your rights today?
I understand, but as far as the
I don't,
license
no,
thing,
no, no, don't say too much, okay? I don't want the
okay,
state to use something against you, even though you think you're helping yourself, okay?
all right.
All right, let your attorney speak for you. Mr. Haddad knows what he's doing. All right, Ms. Morgan, please proceed with your position regarding bond today,
Yes, Your Honor. Am I arguing specifically for position 37 or 38?
or both, both.
Okay, so in regard to position 37, do I need to recite the facts of the case, Your Honor, or are you
Very,
familiar?
very briefly, very briefly. I'm also
Okay,
going to pull the warrant myself.
yes, Your Honor. So very briefly, on June 28th of 2026 at 2005 Virginia Avenue, College Park, Fulton County, Georgia, the defendant followed her boyfriend to his uncle's house. When at the uncle's house, the defendant began punching the victim in his lip and caused his lip to bleed. Police were called. When police arrived on scene, the victim waved the police down and told them what happened. There was a witness on scene that confirmed the defendant was the primary aggressor and confirmed exactly what the victim said happened. In regard to the driving while suspended, hold on one second. I have to pull that one up. I can only pull up one at a time.
And Mr. Jordan, while you're there, can you please check your chat?
So, Your Honor, this case, as far as the driving while suspended and failure to have a license on person, occurred back in, it looks like 2015. And basically, the defendant was driving while her license was suspended, and she did not have a license on her person when she was pulled over. In regard to bond for both cases, on position 37, the battery family violence, we're requesting that the bond remain as set, which is a $1,000 surety bond. And on the position 38, driving while suspended, failure to have license on person, we are also asking that the bond remain as set, which is $1,000 surety on each charge, Your Honor. So a total of 3. Maybe I should break that up, but in total, we're
No,
asking.
I got you. That's okay.
Okay.
All right, let's see. And the 17C, I'm assuming the driving charges results from the FTAs. Is that right?
I'm not exactly
I
sure
think so. I'm
how
assuming
detailed
so.
that.
Okay. All right, Mr. Haddad.
Judge, and I don't know if the state is reducing the offer, I mean, the bond on the family violence battery, but as of now, it's a $2,000 bond on the family violence battery. I just want to be clear on, at the SEA level, that's what the court issued. Judge,
That 2,000, Your Honor. I misspoke. My apologies.
Okay.
Sorry about that, Judge. It's the neighbors, loud people.
It's okay. It's loud at my house as well. Kids are out of school. I'm glad that you can hear me.
Judge.
It's okay. My house is loud as well. I'm glad you all can hear me at all. Please proceed, Mr. Haddad.
So, Judge, she's 38 years of age, Judge. She's been in custody for 11 days since June 28th. She doesn't have stable employment. She works off and on. The alleged victim is not a boyfriend. He's basically a drifter. He's never really they've not lived together. I'm not
Does she
really
have
sure.
she has a stable address, Mr. Haddad?
She informed me that she does, and it's on whatever the address. I'll look it up.
I'm just concerned she has a lot of FTAs. So
I know.
does she understand the importance of coming to court this time? Because if she gets she's now get another pass if I decide to do it today.
Well, I think the court's admonishment is sufficient. I did not address that with her specifically, Judge, but I mean, I can't change her prior history. But she did inform me that she does have a current address. I would ask for as low of a bond as possible, if not through pretrial services, Judge, and a stay, of course.
All right. Okay. So as it pertains to, let's see. Hold on. Let me go back. I've since lost all my information. Okay, so as it pertains to that battery family violence, I am going to change it to a $2,000 signature bond at level 2 with the stay away per judge, with the stay away and the no contact provisions as currently existed. As it pertains to the driving offenses, those will be $5 cash bonds each. All right. Is there, and she's not to drive unless she has a valid license. Is there anything additional?
No, Judge, and I guess just to be safe, we can reset it for next week in the event that
She doesn't make the bond. Okay.
All right, thank you,
Well, you
Judge.
know what, since she's going through pretrial anyway, I'll add those to the pretrial. All of them will go through pretrial services. I am going to require that she report the entire 12 months, not just the 6 months that is standard though, because of the FTAs, to make sure she stays on top of this. Okay.
I'll do that, Judge, and I'll prepare the order and submit it to Mr. Jordan.
All right.
Was that level 2, Your Honor?
It was level 2.
Okay, thank you.
All right. Best of luck to you.
Thank you, Judge.
All right. We're going to take a very, very brief hold and I'll be right back with you.
Before you go, did you want that to be still to be $5 for the pretrial release?
No, send those through you can make those 1,000 each through pretrial
Okay.
services level 2. Thank you, Mr. Jordan. 1 second. All right, Ms. McLeod, I am back. Does your client understand and wish to take the plea?
Your Honor, I wanted to address the issue of the fine again. I believe there is a provision that allows a judge to suspend the fines. I don't think it is a rigid fine that is not suspendable by the sentencing judge. There is a code section.
I'm not gonna suspend it, Ms. McLeod. So if he wishes to take it, I'm gonna go with what the statute requires. Is he gonna take the plea or what? I mean, I'm not gonna do the class that they asked for, but it would be time served and the $300 fine or 30 hours of community service.
Yes, Your Honor, he is gonna take the fine. He is gonna take the plea, and can his probation be ended once he has paid or done the community service?
Yes, which one is he gonna do? Is it gonna be community service or is he gonna pay the fine? Okay.
Fine.
All right, so it'll be a $300 fine and his probation will terminate once he makes that payment. All right, so Mr. Wheelock, we went through the questions. You fully understand that there is a $300 fine. You'll be on probation until you pay it. As to the charge of obstruction, how do you plead?
Guilty, Your Honor.
All right, I accept your guilty plea. Is there anything additional from the state or from the defense?
Nothing from the state, Your Honor.
Your Honor.
All right, best of luck to you, Mr. Wheelock.
You too.
Thank you, Your Honor.
All right, thank you.
Next is position 11 and 12, Ms. Dollar.
Mm-hmm. 11 and 12. Ms. Dollar, your case is 26 CR 004271C. You're charged with criminal trespass, disorderly conduct, and discharge of a firearm. You understand your rights today?
Yes, ma'am.
All right, thank you. I have this. I don't have an announcement for this one.
That is correct, Your Honor.
Go ahead, Ms. McLeod.
Yes, because the state has said that they don't have an offer. They are looking into it, but my client has already been sentenced in another case, and she just wants to get this resolved. So, if the court would like to see if she can have time served, because I've talked to her about it, and she is willing to plead if it's going to be time served. Even if it includes some more time, because she's on her way to serve a sentence. And she doesn't want this to be there for her to deal with at a later date. She'd like to get it dealt with now.
Okay, this is the first time this case has been on SAP?
I believe so, Your Honor.
Okay. Let me look at something I'm looking. And the state, I'm assuming that the state has no offer because they have not spoken to the alleged victim. Is that why there's no offer?
Additionally, Judge, in this particular case, there was a gun that is involved in the case. So it is one in which we feel as if we really do need to have an opportunity to speak with the victim. So it's not just a matter of, and because of this and the incident based on the facts alleged to have occurred during a dispute inside of the home. So I would like an opportunity to at least have that opportunity to
Has
speak.
it been okay? And this is the first time on SAP?
I'm looking it up to see if it's the first time or
I
not.
believe it is, Your Honor, but I would like to say when she appeared on SEA, the alleged victim also appeared and made it quite clear that she had no issues with my client.
Okay,
Let me
I'm
just-
still I'm gonna reset it one time. Since there is no time served offer on the table, I understand what you're saying, Ms. McLeod, but I'm gonna give the state one more opportunity. We're gonna reset to next Thursday's SAP. And
Your Honor,
yes.
I wanted to say that I have a leave of absence in, which will run from next Wednesday until the 3rd of August.
Oh, you're gonna be gone for us for a while, Ms. McLeod. We will miss you.
Yes, Your Honor.
Okay.
Thank you.
All right. So third. I don't feel I cannot take it today, Ms. McLeod. I don't want to give her.
I understand, Your Honor, and I did assure my client that anytime she sits in the jail, it's still going to count.
It's going to count towards it. Correct. That's very
Anything
true.
that she has going on because of the new statute. So, but I still, she just wants to get everything resolved.
I understand, but we just cannot resolve it today. I'll leave it to you where to, do you wish to waive Ms. McLeod then and send it to a division, or do you want it to stay at SAP, but just be reset in light of your leave?
One thing, Your Honor, I won't be here anyway, even if it goes to the division. I've already waived our arraignment and so on and requested discovery. So all of that has already been done.
All right, so we'll send the case on to the division, and further development will happen with Ms. Dollar's case there. All right?
Thank you,
All
Your
right.
Honor.
All right. Best of luck to you, Ms. Dollar. Your attorney's going to do some additional development in the future.
Position 49, Ms. Woods.
All right, and our announcement for Ms. Woods.
Your Honor, she's actually Mr. Murphy's client, but he's not on, and there was no reason I couldn't talk with her. So I did convey the state's plea offer to her, and she is willing to accept the state's plea offer. And, we just have one request concerning that, which is termination of probation once she does everything.
All right, Ms. Woods, your case is 26 CR 004243A. You're charged with simple battery and criminal trespass and damage. Do you understand your rights?
Yes, ma'am.
All right, thank you. Ms. Morgan?
Yes, Your Honor. As to count one, simple battery, the state's request is that the defendant be sentenced to 12 months of probation, serve 48 days, credit for time served, her balance be probated, she have 8 weeks of anger management, no further contact with Skylar Britt and Lakeisha Smith, and that the defendant stay away from 1350 Mason, Mayson, Turner Road. For count 2, criminal trespass and damage to property, the state's request is that the defendant be sentenced to 12 months probation, 40 hours of community service, no further contact with Skylar Britt and Lakeisha Smith, and additionally stay away from 1350 Mason Turner Road.
All right, is Lakeisha Smith, and what was the other name? Skylar?
Britt.
Are either of those parties present and wish to make a statement? Okay, hearing none, Ms. McLeod, do you so stipulate to 3 elements, and that was your understanding?
Yes, Your Honor, I do stipulate.
All
And we
right.
would only ask that once she's completed all the conditions of her probation, that the probation can be terminated or at a minimum go non-reporting.
I'll allow her to go non-reporting. Ma'am, please raise your right hand if you wish to take a plea.
Right hand.
All right. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, sir. Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
You understand you're giving up your right to trial by judge or jury,
Yes, ma'am.
and you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
Do you fully understand all the requirements as explained to you by your attorney?
Yes, ma'am.
And do you take this plea knowingly and voluntarily?
Yes, ma'am.
All right, as to the charges of simple battery and criminal trespass and damage, how do you plead?
I plead guilty, Your Honor.
All right, I accept your guilty plea. Again, once she's completed the requirements, she can go
So will I get
non-reporting.
out today?
Hold on one second. Once she's completed the requirements, she can go non-reporting. I also will waive 1 month of fees for her. If there are no other holds, I can't speak to whether you have other holds, ma'am, but this case is no longer holding you in the Fulton County Jail, okay?
Okay, thank you.
All right.
Bye, everybody.
All right, take care. Bye-bye.
Your Honor. Officer Melton. You and I have another
Welcome. Bye,
client.
everybody.
Bye-bye. Take care. All right, who's your other client, Ms. McLeod? Let's see if we can take that position.
Yes, Your Honor, he does not wish to appear and he's not going to be taking a plea or anything, but it's position number 23, Jermaine Higgins.
All right, so you're gonna waive and then reset for the division?
That is correct, Your Honor. I've already waived and reset.
All right, Ms. McLeod, does that conclude your business?
For this calendar, Your Honor, I do have some clients on the 11 o'clock.
All right, well, we'll see you back at 11, all right? Take care.
Thank you, Your Honor.
I also have an announcement to make, if the court's ready.
I'm ready.
Number 21 and 22, Mr. Henderson. We've actually received an evaluation on him on this case earlier. He's got an FTA, and I think he needs to be reset to the next Thursday, 11 a.m.
Okay. So 1 week reset, Mr. Bartels?
A reset to the next Thursday, 11 a.m.
Okay, reset comp on Thursday, 21 and 22.
That's correct. Thank you, Judge.
Thank you. All right, who do we have next?
1819, Mr. Flowers.
All right, Mr. Flowers, your case is 26 CR 004314A. You're charged with loitering and prowling, obstruction, and contributing to the delinquency of a minor. Do you understand your rights?
Yes, ma'am.
All right, I have that this is a negotiated plea. Is that correct?
That's correct, Judge.
All right, thank you. Whose case is this for the state?
It's mine, Judge.
All right, please proceed, Ms. Love.
The state's recommendation for count one, loitering and prowling, is 12 months, serve 30 days, balance probated, stay away from Cortland at Buckhead Village, 3005 Peachtree Road Northeast. For count two, willful obstruction of law enforcement, 12 months probation and a $300 fine. Count three, contributing to the delinquency of a minor, 12 months probation, Operation 21 long decision course, no firearms, and no future contact with, I'm going to say his initials because it's a juvenile, TT.
Thank you. Mr. White, was that your understanding, and do you so stipulate?
That's correct, Judge. He's also position 19.
Oh, okay. And he also has 26 CR 001202A, which is in which the defendant is charged with criminal trespass. And I'm assuming that the offer, go ahead and put that offer onto the record, even though it's global, Ms. Lowe.
Certainly, Judge. So for count one, criminal trespass and damage to property, the state's offer is 12 months probation, 12 weeks of anger management, and restitution to Shanae Kirkland. No future contact, no future violent contact with Shanae Kirkland.
All right. Is Shanae Kirkland present by any chance?
I am.
All right. Do you wish to make a statement? If so, please raise your right hand and turn the camera on. All right. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
I do.
All right. What would you like to tell the court?
So I really do like to say that I fear for my life just in general with living in Atlanta by myself. Within within the 4 month span, I've had 3 incidents with him. This is only the first incident. I've had a second incident with him. I even got a police report for that, and it states that he has came to my house and damaged more property. I honestly would like for him to sit here and pay me back for all of the damages that I had to sit here and pay back my apartment complex. I even had to sit here and move, fearing for my safety due to him coming to my house plenty of times, destroying my property.
All right. I do appreciate you coming to court and making that statement. All right.
Thank you.
All right. All right, Mr. White, that was your understanding of the agreement today,
It is, Judge.
and you do stipulate to those elements.
We do so stipulate for the purposes of plea.
All right, sir, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
No.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time that would affect your ability to take a plea today?
Yeah.
Did anyone force you to take a plea today? Is that a yes or no?
Yeah, no, ma'am.
All right. And you understand you're giving up your right to trial by judge and jury by pleading guilty today.
I do.
And you understand that you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
I do.
And you fully understand the requirements of the sentence, including the fact that you will owe restitution to the victim in this case, and you are to have no contact with that victim. You also are going to take anger management, and you are to pay a fine. Do you fully understand all the requirements as explained to you by your attorney?
You can say it again.
Okay, let me have the state put those back on to the record for me because I'm unclear as I did it piecemeal. Ms. Love, I apologize. Can you put the requirements of the sentence back onto the record for me very quickly so that because I think they were a little bit different from what I see on the calendar.
Okay, you want for both cases for Mr. Flowers?
Yes, please. Yes, please,
Okay.
very quickly.
All right, starting with count one, 12 months served, 30 days, balance probated, stay away from Cortland at Buckhead Village. The address is 3005 Peachtree Road Northeast. Count two, 12 months probation, a $300 fine. Count three, 12 months probation, Operation 21 long decision-making course, no firearms, no future contact with, given the initials, TT, who was a juvenile. And then for position number 19, 12 months probation, 12 weeks anger management, and then restitution to Shanae Kirkland and no future violent contact with Shanae Kirkland.
All right. Those requirements, Mr. Flowers, do you fully understand them as just listed by the state and as explained to you by your attorney?
I do.
All right. As to the charges in the case ending in 4314A, in which you're charged with obstruction, loitering, and prowling, and contributing to the delinquency of a minor, how do you plead?
Guilty.
And as to the charge of criminal trespass and damage to property in the case ending in 1202A, how do you plead?
I ain't do damage. She talking about.
Okay, do you plead guilty or do you wish to go to trial?
Yes.
I'm sorry, say that again. Pleas are voluntary. Do you feel forced to take a plea? Do you wish to take the plea as it pertains to this?
I plead guilty.
All right. I accept your guilty plea. Is there anything additional from the state of the defense at this time?
Judge, we would just have to find the 30 hours of community service.
All right, I will convert the fine to 30 hours of community service. Anything additional, Ms. Love?
No, Judge.
All right. Best of luck to all parties concerned as it pertains to this case. All right, who do we have next?
Number 20, Mr. Heath.
All right, Mr. Heath, your case is 26 CR 004328L. You're charged with operating a license with a suspended, is it suspended license? Is that it? All right, I believe that's it. Do you understand your rights today?
Yes, ma'am.
All right, I have that this is a negotiated plea. Is that correct?
That's correct, Judge.
All right, thank you. Ms. Lowe?
Yes, Judge. The state's recommendation is 12 months probation, balance probated, 10 days to serve, credit for time served, and a $500 fine.
All right. Was that your understanding of the offer, Mr. White, and you so stipulate?
We do so stipulate for the purpose of the plea, Judge. That is our understanding. We do have two requests. We would like to convert the fine to 50 hours of community service and like to enter this plea as a no-low.
All right. Does the state object to the no-low plea? I'm inclined to give it as it seems to be a driving charge.
No objection, Judge.
All right. Mr. Heath, if you wish to take a no-low plea today, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
You understand that taking a plea, you're giving up your right to trial by judge or jury,
Yes, ma'am.
and you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
No.
And you fully understand the requirements of the sentence that you're going to have to do community service. Has your attorney fully explained that to you and you feel satisfied with his representation?
No.
All right. As to the charge of operating a license with a suspended, I believe it says a suspended license. Let me clarify the charge. Ms. Love, it is operating a license or having an other suspended license. Is that what this is?
Judge, I believe so. Give me one moment and I'll pull them
Operating a motor vehicle with other license while suspended or revoked. I'm assuming that's what it is, but I want to be clear.
Yes, Judge, that's my understanding.
All right. As to that charge, Mr. Heath, how do you plead?
Yes.
No. How do you plead? You're gonna plead no low?
No-low. Mr. Heath.
Mr. Heath, how do you plead? You're gonna plead no low, correct?
Yes.
All right. We need you to say no low.
No, no.
All right. I accept your no low plea. All right. Is there anything additional from the state of defense?
Judge, I think the confusion is the operating motor vehicle with other should have been without.
Okay. Yeah, I never seen a charge like that. Thank you for that, Mr. White. That does make a lot more sense. I was very confused. All right. Once he completes the requirements, his probation will terminate. Okay.
Thank you, Judge.
All right. Who do we have next?
Then 31 and 32, Mr. Malone.
Is this a negotiated plea?
No, Your Honor, this is going to be a not guilty, and we're asking for a bond hearing.
Okay, Mr. Malone, your case is 26 CR 001956D. You're charged with battery family violence. You also have 26 CR 4270D, in which you're charged with battery family violence. Do you understand your rights?
Yes, ma'am.
All right, thank you. Ms. Stallworth, can I please have the history for position 32 and 31 and 32?
That Malone. Yes, Your Honor. He has 8 cycles total, 1 from the U.S. Army. There's a 2018 NOLO from Doraville for knowingly driving motor vehicle on suspended, canceled, or revoked registration and driving without a license, with a suspended or revoked license. There's an open case out of Clayton County for fleeing or attempting to elude, and a 2015 conviction from the U.S. Army for wrongful use and wrongful possession of marijuana. Nothing further.
All right, thank you. Ms. Morgan?
Yes, Your Honor. One moment. And I do have to pull up each separately just to make the court aware because it just takes a little bit of extra time. But in regard to position 31, family battery, family violence, on March 23rd of 2026, Your Honor, the defendant grabbed the victim, Alexis Watson, and attempted to throw her on the floor, causing a cut on her hand. And they were in a romantic relationship at that time. One moment on the other case. So on the other case, Your Honor, that occurred on June 24th of 2026 at 2500 Pleasant Hill Road, apartment B27 in Atlanta, Fulton County, Georgia. And this one was committed against the same victim, Your Honor, Miss Alexis Watson. And this occurred, they also have a child together, Your Honor. And what occurred in this situation, Your Honor, was that the defendant asked the victim to leave the house. The victim was not ready to leave the house that they do share together. So the defendant pushed her into a wall, and then he picked her up and carried her down the stairs and put her out the house. So for the second case, Your Honor, the state is requesting that bond remain as set, which is a $5,000 cash bond. And on the first case, the state is requesting that bond remain as set, which is a $2,000 surety bond, Your Honor.
Okay. And I'm sorry, I need those victims' names again so I can sound just to make sure.
Alexis Watson.
All right. Is Ms. Watson present and wishes to make a statement?
Yes.
All right. Please turn your camera on.
Okay.
Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge?
Yes, I do.
All right. What would you like to tell me?
I would like to say I was never in fear of my life or my physical safety. I would like to remain in contact with him as well because we share a 1-year-old disabled child, and I'm not able to provide for him as much as I can. And I don't want to see him prosecuted for these charges.
All right. I appreciate you coming to court to make that statement.
Yes, ma'am.
Mr. Judd?
Yes, Your Honor. Mr. James Malone is 37 years old. He's lived in Atlanta his entire life. He is a graduate of Banneker High School in Union City. His whole family lives in or around Fulton County. That includes his grandparents, parents, siblings, cousins, aunts, uncles. Your Honor, he has an apartment, 2500 Pleasant Hill Road, apartment B27. The lease is in his name. I believe the bond order has a stay away order, but the lease is in his name. And as we just heard from the complaining witness, Ms. Watson, she is not in fear of her life. She wishes to still have contact with him. Mr. Malone does, in fact, dispute that he ever touched Ms. Watson, that this was, in fact, a verbal dispute, that he did want her to leave at the time, and that she had then called the police to make these allegations, which are false. Your Honor, Mr. Malone is a veteran of the Army. He served for 6 years, honorable discharge. He did a tour of duty in Korea. He served from 2010 to 2016 and then reserves for the following 2 years until 2018. He does take care of Ms. Watson and their 1-year-old disabled child. She has written an affidavit and sent it to both me and the prosecution stating that she does not wish to pursue prosecution. I understand that it's the state's case, not hers, but nonetheless, she is an unwilling witness. Your Honor, he has no prior violent crimes, no sexual crimes. I didn't hear any failure to appears. He's currently retired and living on a fixed income from the military, and he is supposed to be starting school at Lincoln Tech in East Point to get a forklift license. Your Honor, we really do believe that he deserves a signature bond. However, the court is not inclined to give a signature bond. We would ask that both bonds be a surety bond of a low amount. As of right now, that cash bond is preventing him from getting out.
Okay. All right, I'm not going to change any of the conditions on the bond, but I will convert the 5,000 cash to 5,000 surety. All other conditions will remain as set. All right?
But he still needs to stay away from the apartment that is under his name.
If the victim is still there, I'm not going to change that. I'm not going to change the contact provisions. All right? All right. All right. Best of luck. Wait, it was no contact on the original bond? Can somebody clarify that? I'm not going to change what the original judge did for that, but I will change the money amounts. I just want to clarify what it was. Ms. Morgan, do you know what it was?
You're on mute, Ms. Morgan.
I'm pulling it up now, Your Honor. So I'm assuming whoever gets to it first.
The internet runs a little slow here at the jail, but I will try.
Okay, and mine at home is almost impossible. That's why I rely on
It was no further contact, yeah.
Okay. Yeah, I'm gonna leave it like that. The stay away is the if what we can do is he can return one time with a member of law enforcement. If she's not there, he can return to his home. If she still resides there, he'll have to collect his items and stay away. I understand the difficulty, but we are not gonna displace an alleged victim. And I do understand. Wait a minute, hold on. Let me look at one thing. The state's proposed offer today, had he taken it, would have been a no further violent contact.
That is correct, Your Honor.
Okay. What I'll do is this. I will allow him to return to his home, Mr. Judge, and have no further violent contact with Ms. Watson if he also agrees to enroll in FVIP. Would you like to speak to your client about that?
Just for 30 seconds, Your Honor. Your Honor, that's acceptable to Mr. Malone.
Okay. So it'll be a $5,000 surety instead of the cash, the $2,000 surety. Instead of the cash, he's going to enroll in FVIP, have no further violent contact with the victim.
Yes, Your Honor. And the stay away will
And I'll lift the stay away as long as he must enroll in FVIP within 1 week of his release. Okay?
Thank you.
All
Your
right.
Honor.
All right. Best of luck to you, sir. Who do we have next?
Number 5, Mr. Bowers. Number 5, Mr. Bowers. Byers.
Mr. Byers, your case is 26 CR 004297E. In this matter, you're charged with loitering and prowling. Do you understand your rights today?
Yes, ma'am, I do.
All right. I have that this is a negotiated plea, Mr. White. Is that correct?
That's correct, Judge.
All right. Thank you. Whose case is this for the state?
It's mine, Your Honor.
All right. Please proceed, Ms. Douglas.
The state's offer is 12 months to serve 13 days, credit for time served, balance probated, and to stay away from 1123 Chattahoochee Circle in Roswell.
All right, Mr. White, that was your understanding and you so stipulate?
We do stipulate the purpose of the plea. So I assume the balance probated actually meant balance suspended since there is nothing for him to do on probation, which is typically how these work.
Is that correct? I would assume that as well. Ms. Douglas?
Yes, that's correct.
All right, with that, you wish to move forward? All right, Mr. Byers, if you wish to take a plea, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am, I do.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Anyone force you to take a plea today? Anyone promise you anything in exchange?
No, ma'am.
You understand you're giving up your right to trial by judge or jury? And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt? And you understand that you cannot return to that location?
Yes, ma'am.
All right, as to the charge of loitering and prowling, how do you plead?
Guilty.
All right, accept your guilty plea. Is there anything additional from the state or from the defense?
No,
No, ma'am.
Judge.
All
No,
right.
Your Honor.
All right, best of luck to you, sir. That concludes this case.
Yeah, number 9, Mr. Cosby.
Okay, this is Mr. Cosby was with us on Tuesday, correct? Maybe not.
I
No,
don't
no,
know.
no, no.
It was Cosby, Judge.
Okay, okay,
I would do that yesterday as well.
okay. And what is the announcement for Mr. Cosby's case?
It is a negotiated plea, Judge.
Okay, Mr. Cosby, your case is nope, that's not it. 26 CR 004303Y. You're charged with giving false information. Do you understand your rights?
Yes, ma'am.
All right, thank you, Ms. Douglas.
The state's offer is 12 months to serve, 26 days credit for time served, and a $200 fine. Balance probated.
All right, and that's your understanding, Mr. White. You so stipulate?
That's correct, Judge. We do stipulate for the purpose of the plea. We just ask to convert his fine to 20 hours community service and ask that his probation terminate once he completes that.
All right, it can terminate. Mr. Cosby, please raise your right hand if you wish to take a plea. You swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, you can put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Anyone force you to take a plea today?
No, ma'am.
Anyone promise you anything in exchange for taking a plea?
No, ma'am.
You understand that taking a plea, you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you fully understand the requirements of the sentence, including the community service?
Yes, ma'am.
All right, Mr. Cosby, as to the charge of giving false information, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from the state or from the defense at this time?
No, Judge.
No, Your
All
Honor.
right. All right, best of luck to you, sir. This case is closed.
Yeah, 33, 34, Ms. Nelson. Nelson.
All right, this is a negotiated plea.
That's correct, Your Honor.
All right, Mr. Nelson, your case is 24 CR 0078588. You're charged with possession of marijuana, driving with a suspended license, and failure to obey traffic laws. You also have an FTA docketed as 26 FTA 001151. Ms. Morgan, please proceed.
Yes, Your Honor. In the first case ending in 7858A, the state's recommendation is for count 2 that the defendant, that we will amend that charge to driving without a license. And the recommendation is that the defendant be sentenced to 12 months probation, serve 34 days, credit for time served, balance be probated, and there be a $500 fine. For count 3, we are requesting that the defendant be sentenced to 12 months probation with a $265 fine. And for count 1 being that possession of marijuana, we are willing to no pros that charge as a result or in congruence with the plea. And then for the second case ending in for the failure to appear case, we are willing to no prosecute that one as well, Your Honor.
All right, Mr. Judd, that was your understanding of the offer. You so stipulate?
We do so stipulate for the purposes of the plea. That was our understanding of the offer. So long as those 12-month probations were concurrent, that was our understanding.
Are they concurrent, Ms. Morgan?
Your Honor, the state is willing to allow those to be concurrent.
Okay. Mr. Nelson, if you wish to take a plea, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a plea?
No.
Did anyone promise you anything in exchange?
No.
Do you fully understand the requirements of the sentence?
Yes.
Are you satisfied with Mr. Judd's representation?
Yes.
Do you take this plea knowingly and voluntarily?
Yes.
As to the charge of driving without a license and failure to obey traffic laws, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from State or Defense?
Yes, Your Honor. We are asking that since these are traffic violations, that his probation be allowed to early terminate upon completion of the fines.
It will terminate. Yes. All right. Best of luck to you, sir. That concludes your case.
Thank you. Thank you, Your Honor.
Next we have 36, Mr. Robinson.
And what is the announcement for Mr. Robinson?
Your Honor, this is going to be a negotiated plea.
All right, thank you. Mr. Robinson, your case is 26 CR 004283G. You're charged with committing certain prohibited acts in a bus or rail station. Do you understand your rights?
Yes, ma'am.
Thank you. Ms. Morgan?
Yes, Your Honor. The state's request is that the defendant be sentenced to a time served and that the defendant stay away from MARTA buses and train stations in the Atlanta and Metro Atlanta area.
Okay, so basically he's going to comply with Marta's own suspension. Does he have a Marta suspension?
Hey, Nelson Robinson.
I'm not sure, Your Honor.
Likewise.
Okay, well, we'll just say he'll stay away from Marta, okay? All right. Mr. Robinson, if you wish to take a plea, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No,
Did anyone force you to take a plea?
no, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
All right. Do you understand that taking a guilty plea, you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you fully understand that you cannot return to MARTA?
Yes, ma'am.
All right. As to the charge of committing certain prohibited acts in a bus or rail station, how do you plead, Mr. Robinson?
Guilty.
All right. I accept your guilty plea. The time you served in the Fulton County Jail should close your case. All right. Best of luck to you, sir.
Thank you.
Thank you, Your Honor. And just for the record, it was 15 days in custody, and we do so stipulate.
All right. Thank you.
Number 40, Mr. Walters next.
And is that a negotiated plea?
That's correct, Your Honor.
All right, Mr. Walton, your case is 26 CR 004281C. You're charged with theft by shoplifting. You understand your rights?
Yes, ma'am.
Thank you. Ms. Morgan?
Yes, Your Honor. The state's request is that the defendant be sentenced to 12 months of probation, serve 30 days, credit for time served, that his balance be probated, 40 hours of community service, that he participate in an anti-theft course, and that he stay away from Dollar Generals, all Dollar Generals in the College Park, Georgia area. And the state asks that defense stipulate to the factual basis, venue, and identity.
You so stipulate, Mr. Judd, that was your understanding?
That was our understanding of the plea deal. We do so stipulate for the purposes of the plea. We are asking that his probation terminate early upon completion of the anti-theft course and the community service.
All right, it can terminate. All right, Mr. Walton, if you wish to take a plea, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, Your Honor.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
You understand that taking a guilty plea may affect other aspects of your life, such as probation, immigration, or employment?
Yes, ma'am.
And you understand there'll be no further court dates regarding these charges. You're giving up your right to trial today.
Yes, ma'am.
You're satisfied with your attorney's representation?
Yes, ma'am.
How do you plead to the charge of theft by shoplifting?
Guilty.
I accept your guilty plea. Is there anything additional from State or Defense?
No, Your Honor.
All right. Best of luck to you, Mr. Walton. This case is closed now.
Thank you, Your Honor.
Thank you, Your Honor.
We have 41, 42, 43, Mr. Washington.
And the announcement for Mr. Washington is?
It's going to be negotiated pleas, Your Honor.
All right, thank you. Mr. Washington, you have three cases. The first one, 26 CR 001580B, you're charged with criminal trespass and damage to property. 42, you're charged with 26 CR 004286B, you're charged with theft of lost or mislaying property. And then you also have an FTA docketed as 26 FTA 001178. You understand your rights?
Yes.
Thank you. Ms. Morgan?
Yes, Your Honor. For the first case, the state's request is that the defendant be sentenced to time served and stay away from 155 3rd Street, Northeast Atlanta. For case 2, the state's request is that the defendant be sentenced to 12 months of probation, serve 40 hours of community service, participate in anti-theft course, and stay away from 1071 Piedmont Avenue Northeast in Atlanta, Georgia. And for the third case, the state is willing to no prosecute that case as a part of the negotiated plea, Your Honor.
All right, thank you. Was that your understanding? And you so stipulate to the three elements, Mr. Jed?
That was our understanding. We do so stipulate for the purposes of the plea. We're also asking that his probation be allowed to terminate upon completion of the conditions.
All right. He can go non-reporting, Mr. Jed, okay?
Yes, sir.
All right, Mr. Washington, if you wish to take a plea, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given under the penalty of perjury? All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time? Did anyone force you to take a plea today? Is that a yes?
No.
Or no? I can't hear you. Did anyone force you to take a plea today?
No, ma'am.
Thank you. And you understand you're giving up your right today by trial, to a trial by judge or jury.
Yes.
And you further understand you're giving up your right to have the state prove these charges in these cases against you beyond a reasonable doubt. And you fully understand the requirements of the sentence as explained to you by your attorney.
Yes.
All right, as to the charge of criminal trespass, in the case ending 1580B, how do you plead, Mr. Washington?
Guilty.
And as to the charge of theft or of lost or mislaying property in the case ending in 4286B, how do you plead, Mr. Washington?
Guilty.
And to be clear, you made these pleas knowingly and voluntarily.
Yes, ma'am.
All right, I accept your guilty plea. Is there anything additional from the state or defense?
No.
Nothing from the state, Your Honor.
All right, best of luck to you, sir. That concludes the cases.
Thank you, Your Honor.
I'm looking at 47, 48.
All right, I don't have an announcement for this one. Is this a negotiated plea? What's the announcement for Mr. Whittle?
Your Honor, this is going to be a negotiated plea.
All right, thank you. Mr. Whittle, your case is 23 CR 00156B. In that case, you're charged with battery family violence and simple assault family violence. You also have an FTA docketed as 26 FTA 001200. Do you understand your rights today?
Yes, ma'am.
All right, thank you. Ms. Morgan?
Yes, Your Honor. In the case ending in 0156B, the state is requesting that the defendant be sentenced to 12 months, serve 60 days. He received credit for time served. His balance is probated. He participate in FVIP. He had 40 hours of community service. No further contact with the victim, Nikayla, Nickayla Brantley, and that he stay away from 2121 Hollywood Road, Northwest Atlanta, Georgia. And in the second case, the failure to appear case, we are willing to no prosecute that case as agreement with the plea.
All right. Was that your understanding, Mr. Jed? You so stipulate?
We do so stipulate for the purposes of the plea. That was our understanding. For the record, he has 11 days in custody as of this most recent arrest, and then 52 days in custody on the underlying charges. So totaling 63 days in jail on these charges. And Mr. Woodall does want me to clarify for the court that the reason for the failure to appear was he was in custody at Zacat at the time. He did not knowingly fail to appear.
All right. If you wish to take a plea, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol this time?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
You understand that taking a guilty plea, you're giving up your right to trial?
Yes.
Do you fully understand the requirements of the sentence today?
Yes.
And you are satisfied with your attorney's representation?
Yes.
All right, as to the charge of battery, family violence, and simple assault, family violence, how do you plead, Mr. Whittle? I'm sorry, I couldn't hear you. How do you plead?
Guilty.
I accept your guilty plea. I do need to sound for Ms. Brantley. Is Ms. Brantley present and wishes to make a statement? Okay, hearing none. Is there anything additional from the State of Defense?
No, Your Honor.
No,
All
Your
right.
Honor.
I accept Mr. Whittle's guilty plea. The case is now closed at this time.
Thank you, Your Honor.
Thank you.
All right, going back to number 13, Mr. Duplessis.
Are we ready for that one yet, Miss Evans Battle? Let's come back. I
Yes,
don't know.
sir. Your Honor, I did send out, I sent Mr. White an email with the recommendation for the case. I just sent the recommendations out to him and to the other prosecutors, and it has a recommendation for that particular case on it.
Okay.
Judge,
So you need to speak to him.
yes, Judge, I was looking forward to the chat and I didn't think to check email, but yes, I'll talk to him and relay that.
Okay. So
I'm
can
just
we
having-
come? That's okay. Can we come back to this case? And is there someone else we could take?
I ain't the last one, Judge.
Oh, he is. What's our announcement for number 7? I'm sorry, Tracy. I'm sorry, that's a young lady. Tracy Shiketti. Is that one a waiver?
No, Judge, it's a reset for next week, the 16th.
Okay. And why are we resetting her?
Judge, she has separately, she has a felony case. And one of the reasons I needed to reset is she was convinced that this shoplifting case, the misdemeanor, has been previously resolved. I don't believe it has.
Okay.
That's why I want to double check. But the misdemeanor case is not keeping her in custody, Judge.
Okay, we'll reset. Thank you. And then we're holding on 13. Number 26. I don't have any notes for that. I hope I didn't miss that. Is there an announcement for Douglas Hilton?
Could be better than this stuff, though.
I think, Judge, that might be.
And I don't have anything either.
Yeah,
That's
that's-
Mr. Weiss.
Yeah, that's Mr. White.
I don't have anything for 35.
Your Honor, I was unable to see Mr. Posse. He was in medical yesterday, and apparently he was unable to make it to court today.
Okay, we'll reset him next week. Reset SAP.
Yes,
What about 37 and 38? That was Janicia Ross.
That's the one we had the bond hearing, Judge.
It was?
I
Oh.
th- Was I
Okay,
wrong?
okay. Understood. You're correct. I just didn't write it down. All right.
Now I'm starting to doubt myself.
Me too. I had it written in a different place, and I just want to make sure. Okay, so we're just holding on number 13. We're waiting on Mr. Wade. Do we want to? We'll just wait for Mr. Wade because we're way ahead of 11 o'clock. Let's see. Hold on one second.
Okay. It should be better than no.
Let's see one thing.
Everybody's case was worse than mine. Everybody's that use this Faraday. That's a good
right, Mr. Jordan, can we go ahead and review the calendar while we wait for Mr. White to give us the announcement on number 13? Thank you.
Positions 1 and 2 are reset to the 7/14 SAP calendar.
I apologize. It should be 7/16. That was my
7/16?
bad. My apologies.
No problem. Thank you.
Miss Evans, Battle, I just sent you a text or a chat.
And Mr.
Position-
Jordan, I corrected all Haddad's 7/14 to the 7/16.
I will.
Oh, okay, thank you.
Thank you,
Position
Ms.
3 and
Chris.
4 are reset 7/16 SAP. Position 5 was a plea. Position 6 was a waiver. Position 7 is reset 7/16 SAP. Position 8 is a waiver. Position 9 was a plea. Position 10 was a plea. Position 11 was a waiver. Position 12 was a waiver. We're holding on position 13. Position 14 was a plea. Position 15 was a waiver. 16 and 17 waivers. Position 18 and 19 were pleas. Position 20 was a NOLO plea. Position 21 is reset 21 and 22 are reset to the 7/16/26 competency calendar. Position 23 was a waiver. Position 24 is reset to the 7/14/26 SAP calendar.
And that one should be 7/16 as well.
7/16.
Sorry.
Oh, yeah, you said that earlier. Huh?
I apologize.
7/16, sorry. What was the announcement for position 26?
I didn't have anything for 26 either. Let me see. I had originally needs to speak to. Are we holding on 26? We'll hold for Miss. I think that's Mr. White's case. We'll hold. I think Mr. White's going to tell us about 26.
Okay.
Maybe.
27. 27 is a waiver. 28 was a plea. 29 and 30 were pleas. 31 and 32 are reset for the notice. 32, the bond was amended from 5,000 in cash to 5,000 surety. Oh, did you want those back on the SAP calendar, Judge, or just reset for the notice?
Reset further notice. I don't think it needs to come back to SAP.
Thank you. Position 33 was a plea. Position 34 was null pros. Position 35 is reset to the 7/16 SAP calendar. Position 36 was a plea. Position 37 and 38 were amended bond orders. 37 was amended to a $2,000 sign-on bond pretrial. 38 was amended level 2 for 12 months monitoring. 38 was amended to a $2,000 sign-on bond pretrial level 2, 12 months monitoring. That was $1,000 per charge. 39 is a waiver. 40 was a plea. 41 and 42 were pleas. 43 was null pros. 44 was a non-negotiated plea. 45 and 46 was release. 47 was a plea. 48 was null pros, and 49 was a plea.
Any comments, changes, corrections, or questions?
Yeah, I was unable to catch the announcements for 31 and 32.
So on 31 was the bond hearing. The bond amount remained the same. Judge Williams amended the conditions to no further violent contact, and she removed the stay away from that bond.
And I added
32.
FVIP.
Oh, the FBFP. Thank you. Position 32, the bond was amended from a $5,000 cash bond to a $5,000 surety. She removed the stay away conditions and the no further contact was amended to no further violent contact. And he has to take an FBIP class and must enroll within 1 week of release.
Okay, perfect.
All right, Mr. White, did you have an announcement for position 26?
20, that's going to be a waiver, Judge.
Okay. Thank you. All right, as it pertains to 13.
So, Judge, apparently there's a misunderstanding. The state did not have a new offer for us. We already had an offer yesterday. And so we are back to square one and we're asking for a bond here.
Okay. I closed it down. Just give me 1 second. Oh, yikes. All right, let's see. 12, 13. All right, Mr. Duplessis, your case is 26 CR 004269J. You're charged with where's Mr. Duplessis? There he is. Fair evasion, obstruction, a simple assault, and disorderly conduct. All right. Miss Stallworth, can I have the history, please?
Yes, Your Honor. He has 45 cycles total, 21 from the state of Florida. There's an active warrant from the city of Atlanta for burglary. June the 3rd of 2026 is that date. There is an open case out of Cobb County for theft by shoplifting. An open case from Fulton, 26 SC 000413, burglary second degree, criminal trespass, theft by taking, failure to use crosswalk, and willful obstruction. There's another open case, 26 PI 004662, theft by taking and burglary second degree. Another open case, 26 PI 004661, also theft by taking and burglary second degree. He's currently on probation for case number 24 CR 008392J, theft by taking. And there are 3 other open cases, 25 SC 007675, theft by shoplifting, and 25 PI 005353, and 25 PI 005352. Both are burglary second degree. There's a 2022 conviction from Clayton County for theft by taking, 2019 from Cobb, theft by shoplifting, 2019 from Clayton. I didn't write that charge. And then a 2019 from Fulton, theft by taking, 2017 from Fulton, theft by taking and criminal trespass, and a 2016 from Fulton, theft by taking, financial transaction card fraud, and burglary second degree, as well as 11 other convictions outside of the 10-year period, and a 2026 FTA from Clayton. Nothing further.
All right, thank you. Ms. Evans-Brown?
Yes, Your Honor. In this particular case, it appears that on June the 25th of 2026, he was at MARTA Midtown Station. He didn't pay the proper fare. He was instructed to stop. He fled the scene. The officers, of course, had to chase him. They conducted a search of the immediate area, and he was observed later and arrested at 48th Street Northeast in Atlanta. He was attempting to hide behind bushes and cars. He refused to comply with the commands, refused to get on the ground after being given instructions by several officers. They were eventually able to make the arrest. He was displaying aggressive behaviors. He kicked the rear passenger window in the protective cage. He was spitting on the officers at the time. Based on his history, the bond was set. I'm not sure what bond was asked for by the state at that time, but I do.
$12,000. No, that's a current bond. Go ahead. I'm sorry.
Yes, I noticed that was what the court set was a $3,000 bond as to each count, and I'm sure it's based on that significant multi-state history he has. So our bond recommendation, of course, would be, I don't know that I'm opposed to a reduction in the bond, but I would ask the court to set a surety bond in this case. And I would ask that it be, if the court would be so inclined to at least do a 6,000 surety on the case, then the state could agree to that.
All right, Mr. White.
Judge, unfortunately, Mr. Duplessis can't make any bond. We are asking that he be able to sign his own bond. I do know that he has a significant history. Did not hear any violence in that history. It was mostly theft charges. He is a caregiver for a 77-year-old woman. He's been caring for her for about 6 months now. He's been in jail 14 days and has been unable to make his current bond. He does say that he vehemently denies any assault or disorderly conduct charges. He says there'd be video there to exonerate him.
Okay.
Fact
What
that
I'm gonna do is the defendant's gonna get a $4 cash bond, Mr. White. I can't quite give him a signature bond. We'll reset him 1 week to see if he makes the $4 with the same conditions. I won't change the conditions. Is there anything additional, Mr. White? Did you wanted to tell me? I didn't mean to cut you off, but I do agree with you to a degree.
No, Judge, that'll be great. Thank you.
All right, he's gonna get $1 each count, reset SAP 1 week to see if he makes the $4. Okay?
Thank you.
All right. All right. I think we've completed SAP. All those who don't need to remain with us for the 11 o'clock calendar are free to go at this time.
Thank you, Judge. Have a good one.
All right, take care, everyone.
Excuse me, Judge Williams?
Yes.
This is the court reporter. I was wondering if there are going to be any pleas from the competency
I was
council.
just about to ask Mr. Bartels that. Mr.
thank
Bartels,
you.
if you would unmute and let me know if we can expect any pleas at this calendar, such that Ms. Greenhouse should remain with us.
Yeah, Ms. Greenhouse, I think there's going to be at least one. I'm still waiting to talk to a couple of folks. I have some offers, Judge, from Ms. Battle. I'll need to talk to those folks when they get in the courtroom, and a couple of others that I'm waiting on offers for, but that shouldn't take too long.
Okay.
Okay.
All right,
Thank
Ms.
you.
Greenhouse, if you'll stay with us just a little longer, and everyone else who does not need
Thank
to
you.
remain for 11 o'clock is free to go at this time.
Judge
Okay.
Williams? On that last case, you said $1 cash for each charge?
Yes, so it's what, $4 total? He has 4
$4 total?
charges?
Okay, thank you.
Yes, please. Thank you, Mr. Jordan.
Is it gonna go? Where's she? Like, looking for? We are ready to begin whenever everybody's ready to start. We're gonna have 3 pleas. Judge, I've put those in the chat.
Okay. We'll start with position 8 then.
Mr. Thor, you can come up next.
All right, Mr. Coer, my name is Judge Melanie Williams. Today, your case is 26 CR 002263A. That matter, you are charged with criminal trespass. You have the right to remain silent. You have a right to an attorney. And as you can see, I'm conducting today's hearing by video. Do you understand your rights and how I'm conducting the hearing today?
Yes, I do.
All right, thank you. I appreciate that. Ms. Evans-Bettel?
And you said that's Mr. Parks?
Mr. Coer, position 8.
Coer. Okay. Yes, Your Honor. The state is asking that it appeared on my calendar that he had 88 days, maybe more than that. That was on the calendar, and the state would just ask that we commute it to time served at this time.
All right. And is there a stay away?
There should be a stay away from the property, and did not look it up. So
And that's our understanding, Judge, and he served 95 days as of today.
Okay.
Say that again.
He has served 95 days as of today, Your Honor. It's a restaurant, and Mr. Coer understands that he can't go back to that. Yes, sir.
All right. Mr. Bartels, that was your understanding of the offer. And do you so stipulate to the 3 elements in this case?
We do so stipulate, Your Honor.
All right. If you wish to take a plea, Mr. Coer, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given under the penalty of perjury? All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a plea today?
Last week.
I'm sorry, I can't hear. Talk as loudly as you can. Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange?
No, ma'am.
Did you understand that taking a guilty plea, you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you understand that you're giving up the right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you further understand that taking a guilty plea may affect other aspects of your life, such as employment, probation, immigration, or other matters?
Yes, ma'am.
All right, as to the charge of criminal trespass, how do you plead, Mr. Coer?
Guilty.
I accept your guilty plea. Is there anything additional from the state of defense at this time?
No, ma'am.
No, Your
All
Honor.
right. All right. All right. Best of luck to you, Mr. Coer. This case is now closed.
Thank you, Your Honor.
Yeah.
You're talking about I need to get in court, sir. Lawyer. I'm interested in not waiting 80 days or 95 days before I go to jail. I'll plead guilty if I get out of jail. I need to speak.
Maybe we should we mute Mr. Bartels while we figure out what I don't want to, yeah, let's just, yeah.
So this didn't happen, sir.
Judge Williams, while we're waiting, Was there a dollar amount for the restitution on Sean Flowers' case?
There, I
Or
saw that. I don't think so. I think what
oh,
would
okay.
I think that they and I should have clarified that. I should have asked if it's going to be open for 30 days. That was the
Oh, okay.
young lady who spoke. Miss Evans Battle, if you could look at that quickly, that Mr. Flowers from SAP, and determine whether or not the state was asking that we just said restitution, and I should have clarified it then. When he took the plea, I think he understands that do we still do a restitution calendar, Mr. Jordan, or no? We haven't done that in a long time.
No, we haven't done one.
We haven't done one in a very long time, so I don't know how that gets calculated. We should have either put the amount on the record at SAP or indicated that it was going to be handled within 30 days. So can we take a look at that too? Mr. Bartels, we may need you to we have a SAP issue, and I know that everybody from SAP is gone. And this was my oversight. When we did one of the particular positions, there was we indicated the defendant was going to have to pay restitution. This is Mr. Flowers, but we didn't put the amount of restitution onto the record, nor did we say it was going to be resolved in 30 days. So Ms. Evans Battle's going to look at it for me. Do we know the restitution amount? That would just solve it if you did, Ms. Evans Battle.
Your Honor, if Odyssey could work with me, that would be wonderful.
Okay. Yeah, mine is moving extremely slow too. But we don't do SAP restitution calendars anymore. We haven't done that in a long time, and I don't know how to fix that other than saying something. We have to say something.
Just so I got it right, the plea's already been entered, and restitution was supposed to stay open, but there is no restitution hearing.
No. What's happened was we just said pay restitution, but we didn't put the amount, and we didn't indicate whether or not it was going to be, ascertained in 30 days for him to pay. We just said restitution, and really that's not clear or good enough for the order.
Y'all need me to clarify with, I guess it was Mr. White or Mr.
I think it was Mr. White. Mr. Jordan, do you remember? Let me look it up. I think it was who represented Flowers. Yes, it was Mr. White. We didn't say the amount of restitution, and I guess what we'll have to do is say leave it open for 30 days, and then ask if that is problematic because we don't have an amount. But if we have the amount today, Ms. Evans Battle's going to look, then we shouldn't have an issue.
All right, well, I can just let him know after court that this is an issue and y'all are looking into it.
Okay. In terms of the order, I'm trying to figure out what we're gonna put. I guess I have to put on the order, leave it open for 30 days. Because the defendant understands he has to pay restitution.
Right.
So, okay, we're moving on. We'll come back to that in a short moment. Is this Mr. Parks?
Yes, Your Honor. This is number 14, Mr. Parks.
Mr. Parks, your case is 26 CR 0043196C. You're charged with theft by taking. You understand your rights?
Yes, ma'am.
All right, thank you, Ms. Evans Battle.
Yes, Your Honor. As to Mr. Parks, it would be 12 months served, 90 days, balance suspended, no further contact with the victim. The victim is off, maybe that should be no further contact with the victim is Officer Chanel, SHINALL. Stay away from the 26 Marta Street, Northwest address. Let me see if we have her first name.
Hold on. This is a theft by taking charge, correct?
Yes, Your Honor. He took a bag belonging to an officer.
Oh, okay.
She was able to retrieve it
Okay.
right there, so there's no restitution or anything.
Okay. All right, Mr. Bartels, that was your understanding and you so stipulate?
Yes, Your Honor, that's our understanding, and we do stipulate to the 3 factors for purposes of the plea.
All right, Mr. Parks, if you wish to take a plea, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury? All right, you can put your hand down. Are you under the influence of any drugs or alcohol this time? Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
You understand that taking a guilty plea, you're giving up your right to trial by judge or by jury,
Yes, ma'am.
and you're giving up the right to have the state prove these charges against you beyond a reasonable doubt.
Correct.
And you further understand the requirements of the sentence as explained to you by your attorney.
Yes, ma'am.
All right, and you take this plea today knowingly and voluntarily.
Correct.
All right, as to the charge of theft by taking, how do you plead, Mr. Parks?
Guilty.
I accept your guilty plea. Is there anything additional from the state or from the defense at this time?
Nothing from defense, Your Honor. Thank you.
No, Your Honor.
All right, best of luck to you, sir.
Thank you, Your Honor.
Okay, give me 1 second. This is position 20, is that correct?
That's correct, Your Honor. Mr. Tasco.
Oh, come on. Okay, Mr. Tasco, your case is 26 CR 004212L. In this matter, you're charged with pedestrian in the roadway and giving false information. You understand your rights?
Yes, ma'am.
All right, thank you. Ms. Evans Battle?
They're waiting for
Yes, Your Honor. As to this particular case, I believe we're going to ask that we commute to time served. I had 17 days. He may have something different in this particular case.
Yes, ma'am. That's what I have, 17 days.
Okay. All right, Mr. Bartels, you stipulate to 3 elements, and that was your understanding of the offer today.
We do stipulate, Your Honor, and that's.
All right, Mr. Tasco, if you wish to take a plea, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange? You understand that taking a guilty plea, you're giving up your right to trial by judge or jury, and you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
Yes, ma'am.
And you further understand that taking a guilty plea may affect other aspects of your life, such as any other open cases, probation, immigration or employment, or other things your attorney and I may not be able to anticipate. Do you understand that? All right, and you're satisfied with Mr. Bartel's representation? All right. With that, how do you plead to the charge of pedestrian in roadway and giving false information?
Guilty.
I accept your guilty plea. Is there anything additional from state or defense?
Nothing from defense, Your Honor.
All right. Best of luck to you, sir. That concludes your case.
Thank you.
Thank you, Your Honor. Good luck. Take care. Here.
All right. Are we complete with the pleas? Will there be any more?
That is it for please, Your Honor. Just status and announcement. I think Ms. McLeod has a couple of cases when the courtroom's clear, but she has Mr. Arnold, who is number 1 through 6. And I believe she has Mr. Ponder. Oh, there she is. Hey, Ms. McLeod.
All right. We'll wait to clear. All right. Courtroom is almost clear, I believe. And Ms. Greenhouse, you're free to go. We're not going to take any other pleas. Thank you.
Okay, thank you so much. Have a good day.
All right, we do need to probably still go into the breakout. There may be members of the public on the Zoom. So if we can put courtroom 2, myself, Ms. McLeod, Ms. Evans Battle, and the 2 social workers.
Looks like Mr. Clark, Kevin Clark I think he's the father. Hey, Mr. Clark. I think Mr. Clark is not on this calendar. Connor Clark, he's on next week's calendar.
I'm looking.
Yeah,
No, he's not on the calendar today.
right. Because I understand, Mr. Clark, that y'all were asked to be present at Connor's next court date, but it's not today. It's next Thursday. It's the 20th.
Oh, okay. She sent me a link, said I needed to be on today.
Okay. Yeah.
My apology. I had it, my notes said it was going to be continued until today. So I had the victim advocate to reach out to him.
It's next week.
I think there was some discussion about whether to stay 1 week or 2 weeks, but I guess they finally decided on the 16th.
Okay.
All right.
Apologies, Mr. Clark.
Oh, no
taking
worries.
your time.
Oh, no worries at all. Should I go?
Yes, you're free to go. Take care, Mr. Clark.
Okay.
I'll
And
Thank
if
you,
we
Your
we
Honor.
could turn off the YouTube for